All right, welcome everyone. Thank you so much for joining us today for the webcast COVID-19 and the Workplace, Legalities and Labor Costs, sponsored by HR.com, presented by Stuart Rudner and Brittany Taylor, both of Rudner Law. So if you have questions during the webcast, please click Q&A in your webinar controls and type your questions there. Once the presentation has begun, I'll share a couple of links in the chat area. One, you can access the slides, and the other will prompt an exit survey to open in a new browser on your computer. So please be sure to complete the survey once the webcast has ended. Okay, and that's it for logistics. It is now my absolute pleasure to turn it over to Stuart and Brittany.
Great, thanks so much, Rhonda, and good morning or good afternoon, everyone, depending on where you are, I suppose. Just by way of brief introduction, I'm sure most people want to hear about COVID-19 in the workplace, but just to let you know who Brittany and I are and why we're talking about this, and hopefully why you should pay attention. Rudner Law is a law firm that specializes in employment law. In fact, that's all we do. We work with employers and employees, so we see both sides of all the different issues. Usually what I say is that most of our time is spent dealing with issues that arise like wrongful dismissals and terminations, hiring, harassment, accommodation, and all the things that come up in the work relationship. And of course, doing the strategic work, which is what we really like to do, where we help our clients with their contracts, their policies, procedures, trying to basically help them avoid issues as much as we can. That's what we truly enjoy doing. But frankly, the last 2+ weeks have been spent talking about COVID-19 and the workplace and what that means for the employers, for the employees, and how we can all get through this. And so far, it's really been a spirit of how we can all get through this together, which has been quite nice to see. But the reality is we are dealing with an unprecedented situation. And I'm just going to say that right up front so you can count how many times we use the word unprecedented over the course of the next hour. But the reality is that unprecedented and all the other words that we're hearing, they're really not overstatements in this context. What's happening now with the coronavirus has impacted the entire world. It's impacted our day-to-day lives. It's cost many lives, unfortunately. It's impacted the economy on a macro scale, but on a micro scale, it's impacted thousands or millions of businesses and even more individual lives, and people who have all of a sudden been told they have to close their business or they're working on a skeleton staff, people who have been told that they are being sent home, they don't know when they're going to be paid again. It's been devastating for everyone, and everyone is trying to figure out how to get through this. We know that everyone needs help, and the governments know that, which is why every single level of government in Canada has been taking action in order to address leaves of absence and financial support and anything else that they can think of. Everyone knows this is not a wait and see situation. So everyone is taking action, but at the same time, we're all trying to figure out what the next step is and how to protect ourselves, or in our case, our clients. And we're doing our best to help them. The challenge basically is that on the one hand, you've got employers who need to reduce their labor costs, and you've got employees who, anytime a decision is made, will it be impacted. So if you make a decision to lay people off, employees are without a job, without an income. If you reduce our wages, again, they're without or with a reduced income, and they don't know how long it's going to last. And that's what's scary for everyone. And I mean, what's been interesting as well is, at the best of times, we often say that people unfortunately don't have a good understanding of their legal rights and their obligations when it comes to employment. That's true all the time. But it's even more exacerbated in the last few weeks because we are dealing with this, yes, unprecedented situation where everyone is trying to figure out how the laws apply, if they're even taking the time to consider it. The reality is that things keep changing. And Brittany's going to talk a lot about the government initiatives in this case. About a week ago, we were spending most of our time talking about layoffs and how to deal with those. Then our federal government announced the emergency wage subsidy, which in some cases will provide up to 75% of wages. All of a sudden, a lot of businesses are taking a step back and saying, maybe we don't need to lay people off. So the conversation has changed dramatically over the course of that week. And many people are hoping to avoid layoffs altogether, which would be great if this initiative is able to help them do that. Our concern really is what it always has been. People are making decisions without understanding their legal rights and their obligations. From the corporate perspective, they're exposing the companies to potential liability. From the personal perspective, people are often accepting things like layoffs or wage reductions without understanding that they may have a right to either object to it or at least discuss it rather than simply accept that it can be imposed upon them. So really, we want to allow people to make informed decisions. At the end of the day, we'll provide the legal advice. You'll make the decision that's best for you, but we want it to be an informed decision. So we have a lot of things we want to review today. As Rhonda mentioned, we hope to have some time at the end for Q&A session, assuming we can get through all the material we want to cover. You'll see there's very few slides in our slide deck because things keep changing so much, and we'd be spending more time fixing it than we would actually creating it. But there is a lot of information. So with that, because we're lawyers, we have to have a disclaimer. So please bear in mind that you're not supposed to make any copies of this without our permission. But more importantly, this is not intended to replace legal advice. There's a lot of information here. First of all, if you have a specific situation you're dealing with, you should speak with an employment lawyer and make sure they understand all the facts and then give you the advice you need, rather than relying upon information that we can give you over the course of an hour. And as well as that, like I said before, things keep changing so rapidly. And this is another big concern. Information we gave out 4 or 5 days ago may not be valid anymore because things have changed. So please do not rely upon this as legal advice, but hopefully we'll make you aware of some of the issues and make you realize when you may need to get legal advice as you go forward dealing with all these issues. So getting right into it, reducing labor costs. And this is what is the fundamental concern. I can see Brittany laughing at the Bitmoji I threw in last night. This is what every business is struggling with. Well, I shouldn't say every business. Some businesses like ours are actually very, very busy right now, but most businesses are struggling and they are trying to figure out ways to cut down their expenses. They realize that on the one hand, either their business is stopped or it's dramatically reduced. They have dramatically reduced revenues. And on the other hand, they're being told, well, you may not be able to do what you want to do. So people are really struggling to figure out what the options are as they go forward. And I guess the nice thing is that so far, we're not really seeing a lot of conflict. Usually when you talk about terminations, layoffs, downsizing, whatever, it creates inherent conflict. So far, we've been working with a lot of our clients on both sides of the fence, and they've been having very, I'll say, rational, conciliatory, cooperative discussions with the other side to try to find solutions, which might involve the employee taking a short-term hit, such as a layoff or a wage reduction, but it's done for a long-term benefit of everyone to get through this situation. We've been seeing that, and the important thing to realize is that in many cases, as the employer, you may not have the right to impose things. So it's very important to maintain that dialogue, maintain the relationship, and hopefully agree upon what's going to happen, as opposed to imposing it and risking a claim against you. So I'm going to talk about some of the potential options that you may have, and then we'll talk about some of the risks as well. So first of all, temporary layoffs. So the interesting thing is every day we hear media reports about layoffs, and it could be thousands of people, tens of thousands of people. And of course, we have employment standards legislation. And I should mention that where it gets even more confusing, employment is provincially regulated. Every province has its own set of legislation, as do the territories, as does the federal government. Every single one of them talks about layoffs. They talk about how you can implement layoffs. What they don't talk about is the fact that you may not be able to actually go ahead and do so. That right comes from contract. So we're going to talk about that as well. But what I want to make the point of now is we all hear about the headlines. We see the Employment Standards Act and people assume, okay, I can lay people off. People have always assumed that, and it's always been a constructive dismissal. So we're going to talk about that later, but what does it mean, a layoff? It's a temporary termination, basically. It means you're sending them home. They're not going to work. You're not going to pay them, but the relationship continues, and that's where it's different than a termination. So that can be a very effective way to reduce your costs if you have the right to do it. Like I said before, every province has its own legislation. So for example, in Ontario, you can temporarily lay people off if you have the right to do so for up to 13 weeks. It can actually be longer, up to 35 weeks in certain circumstances, such as if you continue their benefits. So that's one way to dramatically reduce your costs on a temporary basis if you have the right. Reduction of hours or wages, same concept. It could be anything from 5% to 90%. You can reduce their time, or in many cases, we've had clients who've gone to their salaried staff and say, look, we're going to ask you to keep doing your full job, but we're also going to ask you to take a pay reduction of 10 or 20 or 30 or more percent. Again, you may not have the right to impose that. In most cases, you will not have the right to impose that, but people so far are being pretty cooperative and agreeable to that. So I'm going to mention two other things very quickly, and then one more thing, and then we'll get to the others. Dismissal. So a lot of employers are taking advantage of an opportunity now, and they're saying we have staff that we don't really need anyways. We plan to get rid of them. This is as good a time as any, so you can terminate their employment. And the reality is in Canada, most of the time you can let anybody go for any reason or no reason at all. Different if you're unionized. If you're unionized, the rules will be very different. Also different if there is a protected ground under human rights. So you can't let somebody go because of their gender, ethnic origin, their disability, and COVID-19, of course, being the best example. Human rights commissions have confirmed that COVID-19 will be treated as a disability. So taking the extreme example, if one of your staff comes to you and says, I've been tested positive, you can't say, we're so sorry, good luck, but we're also terminating your employment. You can't fire them because of that. If it was unrelated, that's a different story. But the other important thing to remember, and I'm going to talk about this, I believe we have a slide on this in a bit more detail. If you're going to let somebody go, you've got to pay them severance, and that can be substantial. So before I move on to frustration of contract, I've mentioned this a few times already. So why can't you lay somebody off temporarily? And again, the assumption is that normally you can, and that's not true. That normally you can't. So what's a constructive dismissal? That's what we're talking about. Constructive dismissal is a unilateral and a substantial change to a fundamental term of the employment relationship. So obviously there's some key words there. First of all, unilateral. If the employee agrees, then you're okay. It's got to be a substantial change. So a 1% cut in pay, for example, is probably not going to be substantial enough. And it's got to be to a fundamental term, like compensation is a fundamental term. And then taking a step back when we talk about layoffs, think about the very fundamental nature of the relationship, which is that the employee will work and the employer will pay them wages in exchange for that work. If you now tell the employee, don't bother working, we're not going to pay you, you have dramatically, not just substantially, you have dramatically changed the fundamental nature of the relationship. And even though that's temporary, that would be a constructive dismissal. There is no automatic right to lay them off or reduce their hours. Again, it could be a nominal change, but if it's substantial, that would be a constructive dismissal. But as I put in large blue letters here, unless your contract gives you the right. You can have a clause in your contract which says we will have the right to lay you off in accordance with the employment standards legislation. And here is one case where we get to say, we told you so to our clients, because when we work with our clients, like I mentioned earlier, we like to be strategic as much as we can. When we draft contracts for our clients, we will almost always suggest including a temporary layoff clause. And 9 times out of 10, the client will say, why is that here? We don't do that. That's not the way we operate. We don't lay people off. And we will usually say, just keep it there just in case. Nobody ever imagined a scenario like this, but I have to tell you, we've had a number of clients who have thanked us profusely because they don't have to get a second thought. They have the right to lay people off without going to them and getting them to agree. Otherwise, you need agreement. Now, I should mention there has been a fair bit of debate amongst the employment law bar in the last few weeks about whether the law will be applied in the same way it always has. So, and a lot of people have taken a very strong position in saying that it just doesn't make sense. And I don't disagree with that. I think businesses right now are stuck between a rock and a hard place. So imagine for the businesses that are told on the one hand, you must shut down and cease operations. And then you've got employment lawyers saying, but you can't lay your staff off. Something's got to give somewhere. So I agree, the law as it exists really does not work for this situation. No one ever anticipated this. And it's entirely possible that at some point in the future, this will go to a court and a judge will say, yes, we can't apply a pre-COVID-19 law to this situation. It doesn't make sense. And we'll give an employer an out. Or it's possible a government will come in and legislate that. But neither of those things have happened yet. So what we're saying to our clients is, if you're going to impose a layoff, you are taking a risk, because the way the law stands right now, it's a constructive dismissal. That might change, but it hasn't yet. So that's something that people really need to bear in mind. We want to make sure that everyone understands that they may not have the right. Best thing to do is get an agreement. In some cases, you'll make an educated, or you'll basically take a risk, but it's got to be an educated risk and knowing the risks. From the employee perspective, because we have been advising a number of employees as well who have been either asked or told that they're going to be laid off, we often encourage them to not, basically commence a war when you don't need to. So most of the time, if you told you're going to be laid off, we'd say, well, I would take a fairly aggressive stance and say that the company doesn't have the right to. In this situation, we're usually encouraging individuals to have a frank but conciliatory conversation and say, I don't think you have the right, but let's see what else we can do. And as Brittany's going to talk about, with the wage subsidies and the other programs in place, layoff may be avoidable. So we've encouraged a lot of people to go back to the company and say, isn't there some other way that you can reduce your costs without laying me off? And that's going to be a more long-term approach. If it's, because otherwise, if you are very aggressive and you say you've been constructively dismissed and you leave, first of all, if a court one day finds that it was not a constructive dismissal, you've now resigned from your job and you've lost your entitlement to any termination pay or employment insurance benefits because you resigned, and you've also lost your job. Whereas otherwise, if it's a temporary layoff, then at some point you're going to be recalled and put back into your job. So you may win the short-term battle but lose the war, which is not a strategic way to do it. Again, you've got to make an informed decision and an educated decision. So dismissal without cause, and I don't want to spend a lot of time on this, but just so people understand, if you're going to let somebody go, or if you constructively dismiss someone, it has the same result, which means you've got to give them either notice or termination pay. And that has three potential sources. Employment standards legislation, it's different in every province, but similar ideas. You're going to have to pay them. It's relatively nominal. The bigger issue is the common law, which says everyone gets reasonable notice. Contrary to popular belief, another myth or misconception out there, it's not a month per year. What the courts have said they will do is they'll look at a whole bunch of factors, including, of course, length of service, but also age, nature of position, availability of similar employment, things like if the person was induced to leave prior employment, and then I'll try to figure out what is a reasonable estimate of how long it should take them to find new work. The unofficial cap in Canada is 24 months or 2 years. So that can give you an idea of your potential exposure if you let somebody go without cause, or if you constructively dismiss them and a court agrees that it was a constructive dismissal. Here's another way where contracts can be invaluable. The other thing we do with our clients is we always make sure there's a termination without cause clause in the contract, which replaces the common law. So instead of trying to figure out what's a reasonable notice period, we will say, in the event of a dismissal without cause, you will get X. And it could be as low as the Employment Standards Act minimums, which are fairly nominal, or it could be something more, but there'll be no ambiguity. And of course, you can cap it. So that's another way to protect yourself going forward. But for now, you need to realize that if you're going to let somebody go, this is your potential liability. And last thing I want to talk about at this point, frustration of contract. So we've heard a lot of people talking about whether this would apply. By the way, I see a question coming in about whether this webinar applies only in Canada. Yes, we practice employment law in Canada. We don't practice in the US. We have a lot of American clients, and we know the employment laws are extremely different, especially when it comes to temporary layoffs. So yes, please do not take this as applying to anywhere other than Canada. And in fact, in Quebec, it's a little bit different as well. But for the rest of the provinces, this would certainly apply. So frustration of contract. This is going back to my first year of law school when I learned about this originally, as my prof explained, frustration of contract occurs when completion of the contract is rendered impossible due to unforeseen circumstances that are not the fault of either party. And his example was, imagine you sign a lease to rent an apartment, and before you even move in, the building burns to the ground. Assuming that's not the fault of either you or the landlord, what happens? Simple answer is nothing. The contract is at an end. Nobody has any further obligations. This concept applies to employment contracts as well. So if usually it comes up in the case of disability, somebody who is working or is going to start working becomes disabled, can't do the job, the contract might be frustrated, but that's a very complicated issue, which I will not get too far into now. The point is, people have said, well, wouldn't this situation we're in now, wouldn't that constitute frustration of contract? I'm not convinced that it would. I think if you are ordered to shut down by the government or by any institution, it's a stronger argument because it's impossible for you to continue employing those people. The problem is that's temporary. We unfortunately don't know how temporary that will be or how long it will last, but the reality is it's a temporary impossibility. Whereas normally when you look at frustration of contract, it's a permanent impossibility. So it's certainly an argument that's available to employers. And if you can show frustration of contract, like I said, you have no further obligation other than some statutory obligations, which would be fairly minimal. You wouldn't have to pay reasonable notice severance like you would in a termination. But I'm not convinced that this argument will succeed. So it might be an educated risk, but I think it would definitely be a risk if you want to take that position that contracts of employment has been frustrated at this point. So I think that's all I was going to cover at this point. I'll turn it over to Brittany, who will talk about the plethora of support that is available, which keeps changing on a daily or hourly basis. So I'll turn it over to you.
Great, thanks, Stuart. And I'll apologize in advance that my Bitmoji doesn't look like me anymore. My bangs have grown out in self-isolation. um, so yeah, so I'm going to be talking about some of the supports that are available. To be clear, I'm going to be talking about both protections as well as actual financial support that's available to both employees and to employers. So we're going to start by talking about employees. And one of the things that I just want to highlight that Stuart has mentioned already is that employment law is governed provincially, but we do have some federal initiatives that have come out designed to protect all Canadians, regardless of jurisdiction. So I'm going to be talking about both some of the provincial supports that are available, and I'll try to keep that a bit general in case we've got people here who are outside of Ontario. But I'm also going to be talking about the federal initiatives, which would apply to everybody, again, in Canada. Okay, so let's start by talking about leaves of absence. So in every single province, territory, every jurisdiction in Canada, there is employment standards legislation which sets out kind of the bare minimum entitlements that an employee has. And this legislation is really designed to protect employees, not to help employers. These pieces of legislation already have a lot of leaves of absence built into them. So some of the most common ones that you'll be familiar with are things like a pregnancy and parental leave. So what a lot of provinces have done in response to COVID-19 is they've either created new leaves of absence to make sure that people who are impacted by COVID-19 who can't work are protected, or they've expanded on existing leaves of absence to make sure that people who are impacted by COVID-19 are still going to be protected. So for example, in Ontario, we already had something called a declared emergencies leave, which could have been applicable to COVID-19. But just to be absolutely clear that this is going to cover employees who are unable to work as a result of this unprecedented situation, the government went ahead and expanded the declared emergencies leave to add an infectious disease emergencies leave, so specifically to address the situation of COVID-19. So what's really important to know about leaves of absence under employment standards legislation is that generally speaking, they are going to be unpaid. So this is not a requirement that employers are paying employees their full salary while they're unable to work, but it is a job protected leave. So the expectation is that an employee is going to be returned to work once the situation has resolved itself or once the leave has expired. In terms of the duration of the leave, that's going to vary significantly depending on your jurisdiction. So for example, here in Ontario, the infectious disease emergencies leave is actually indefinite. So it doesn't have a set end date or a time by which it must end by. What the legislation states is that for as long as the employee is unable to work as a result of COVID-19, they're going to be covered and protected under this leave. Other jurisdictions have not been as expansive. For example, in Alberta, their leave is limited to 2 weeks, which is really designed to cover that quarantine period that individuals are being required to go into, for example, when they return from travel abroad. So some of the other really interesting things to note about leaves of absence, particularly in Ontario, and I've seen this, I think, pretty much across the board in other Canadian jurisdictions, is just that the governments are really relaxing the requirement for employees to provide supporting documentation to take these leaves. So I think the general message that we're hearing is we have no intention and no interest in kind of overburdening the healthcare system by requiring employees to go get medical notes to confirm, yes, I do have COVID-19, or something similar. Yes, I'm at risk for COVID-19. So they've really eliminated that requirement. I think what they have done is say that, in certain circumstances, at the appropriate time, an employer can ask for supporting documentation that isn't a medical note. So it may be that, a couple months down the road, if an employer felt that they required supporting documentation for an employee who's been off on a leave, they may be able to request some of that information, such as, for example, if somebody's taking time off because they've returned from travel, maybe they could ask for, their flight itinerary or something like that, just to support the need for the leave. But I think the governments have been really clear that employers should be flexible at this point in time. And if somebody is saying they need to take advantage of a leave of absence, that they really should be taken at their word and trusted for the time being, because we just don't have the luxury of getting kind of bogged down with administrative issues like, but are you actually sick? So that's one protection that's available for employees. The next protection I want to talk about is human rights legislation. So again, every jurisdiction is going to have its own human rights legislation, but they're quite similar in Canada across all jurisdictions. In Ontario, we have the Human Rights Code. So Stuart's already mentioned that, as an employer, you could not, for example, just dismiss somebody because they come to you and say, "I've tested positive for COVID-19," and that's because COVID-19 has been identified to fall within the protected ground of disability. So just to step back a bit, basically what human rights legislation in Canada does is it sets out a number of protected grounds, including things like age, sex, disability, family status, gender identity and expression, a lot of different grounds. And basically what it does is protect employees from discrimination on the basis of those grounds in various areas of life. And for our purposes, the most relevant one is in employment. It also imposes a corresponding duty on employers to accommodate employees up to the point of undue hardship. And undue hardship is a very, very high burden for an employer to meet. So it's not just, I tried, it was kind of hard, I'm not going to do it. Undue hardship anticipates that some amount of hardship is anticipated in going through the accommodation process. So employers should never assume that they reach that threshold easily. It's actually quite challenging to get there. So if we think about disability as encompassing, the ground of disability as encompassing somebody who has COVID-19 or even somebody who is perceived to have COVID-19, that means that an employer cannot take negative action against an employee as a result of their membership in that protected ground. So again, the example Stuart gave is the most obvious one. You couldn't fire somebody who came to you and said, "I've got COVID-19. But it also means that you can't take other disciplinary action against them as a result of their disability. So when I say accommodation, I think the question that I get most often from employers is, well, how am I supposed to accommodate somebody who has COVID-19? I can't possibly let them into the workplace. That's going to put my other employees at risk. I've got to have reached the point of undue hardship. And I think the thing that's really important to keep in mind is that accommodation can include a leave of absence. So allowing an employee to stay at home, again, on an unpaid leave. There's no expectation that the employer is going to pay them for that time. But again, job protected leave. That can be a form of accommodation. So if you're going to try to argue undue hardship, you're also going to have to demonstrate why allowing them to stay at home on a leave of absence is impossible, or at least extremely, extremely difficult for your business. So that's disability is one area where we can expect to see leaves of absence and accommodation coming up. But another area that's really important to keep in mind in the current climate is the ground of family status, and this is basically the being in a parent-child relationship. So obviously, we have a lot of employees right now who are parents or who are children of elderly parents who are not able to come to work, not because they are sick or because they are quarantining, but just because the schools are closed and there's no daycare available and babysitters aren't coming over because everybody's social distancing. So it's entirely possible that your duty to accommodate somebody with family status concerns is going to include allowing them to take a leave of absence pursuant to the code or other human rights legislation, depending on your jurisdiction. So those are two areas in which the law provides protection for employees who are not able to work. But again, in both of those cases, it's unpaid job protection that they're receiving. So there's no financial income that's flowing to the employee in those situations. So let's talk about some financial ways that the government is assisting employees. So the first is employment insurance benefits. So there's two types of benefits that may be available to employees who are facing a COVID-19 work-related stoppage. So the first is regular benefits. So this is the same type of benefits that would be available even outside of this crisis. Essentially, what this regular benefit is designed to do is provide income replacement for employees who have been either laid off or dismissed. The criteria is basically that you have to have been without work and without pay for at least 7 consecutive days. I know that if you anticipate that you're going to be off work for at least 7 days, you can still apply. That's going to be fine. But what's really important to note about regular benefits is that if you are still receiving income from your employer of any kind, even if it's significantly reduced, you're not going to qualify for EI regular benefits just because there is that preliminary requirement that you be off work for that 7 days. So that's EI regular benefits. There's also EI sickness benefits, which are available to employees who are unable to work as a result of illness or injury. And the government has been very clear to say that this also includes periods of quarantine. So individuals who are required to self-isolate, or even individuals who are self-isolating as a result of a recommendation, not necessarily a required self-isolation, are likely going to be able to apply for EI sickness benefits. And this provides up to 15 weeks of coverage for employees. And just in case anybody's not aware, the usual rate for both regular benefits and for EI sickness benefits is about 55% of an employee's weekly earnings. That is going to vary depending on the circumstances of each employee, but that's generally the regular rate that applies. So something important to note about EI sickness benefits is that as of March 15th, the government waived the usual 1-week waiting period for individuals to receive benefits. And just as we've seen with leaves of absence under human rights or employment standards legislation, there's also been a pretty clear statement that medical documentation is not going to be required for individuals who are applying for EI sickness benefits in this case. Okay, so the next one I want to talk about is the Canada Emergency Response Benefit. So this is a relatively new benefit that we actually have quite a bit of information on, unlike some of the other new initiatives that have just come out. So basically what the Canada Emergency Response Benefit is designed to do is to fill in the gaps of those individuals who otherwise would not be covered under EI. So the government looked at the workforce in Canada and said, okay, there's a lot of people that are not going to be able to take advantage of our employment insurance program because they are self-employed, because they are contractors, because they don't have the minimum number of insurable hours yet, so they haven't worked long enough with their current employer to be eligible for EI benefits. Lots of different people who would have fallen through the cracks in the regular employment insurance system. So the Canada Emergency Response Benefit was designed to address that problem. And what does it do? So it basically provides employees with, they qualify it as a weekly benefit, so it's $500 per week, but it's going to be paid monthly, so $2,000 a month. It's available for up to 16 weeks, and the period of eligibility is between March 15th up to October 3rd. So it is backdated all the way to March 15th and can continue up to October 3rd, keeping in mind though that it is still limited to that 16 weeks. So whenever you apply, you're going to be limited to that 16-week period. So who's eligible for this benefit? So you have to be a worker, which is somebody who's at least 15 years old, who's resident in Canada, and for the last 12 months or for 2019 have at least earned a total of $5,000 in whether that's employment, whether that's from self-employment, or whether that's from benefits under, for example, EI. So if you were on parental leave during that time and you're panicking thinking, oh no, I didn't earn $5,000, don't worry, they're gonna consider the benefits that you receive from EI in making that calculation. Other requirement is that you have to have ceased work for at least 14 consecutive days. So this is double the requirement that we see for EI regular benefits. You have to be off work for at least 2 weeks. And of course, you have to have received no income in respect of that time. So if your employer has sent you home, but they're still paying 100% of your wages or even 50% of your wages, you're not going to qualify for the Canadian Emergency Response Benefit. The other important thing that, and I've gotten this question a few times, is what if I was already unemployed before this COVID-19 situation happened? Or what if I quit because I was concerned about COVID-19? So people who were already unemployed, so they're unemployed not as a result of COVID-19, are not going to be eligible for the benefit. Individuals who voluntarily resign from their employment are also not going to be eligible. So really important, has to be related to COVID-19. Like the whole purpose of this benefit is to cover people who are directly impacted by this crisis. It is not designed for employees who have just been let go or have voluntarily resigned in the ordinary course. Individuals who have just been let go unrelated to COVID-19 can still access EI regular benefits. Okay, so how do you access it? So it's going to be available through the Canada Revenue Agency's portal. It's not actually open yet, but it is opening as of Monday. The application schedule that they've set up to try and make sure that we don't overload and crash their system is based on your month of birth. So individuals, for example, who are born between January and March, they can apply on Monday. Individuals born April to June, they can apply on Tuesday. So there's a bit of a staggered application process. So again, so that the system isn't overwhelmed, and also to give the employees time to start processing these applications as well. So basically, what the other important thing to note is that individuals do have to reapply each month. So it's not a situation where you're going to apply and then just be on it for the full 16 weeks. You are going to have to reapply at the start of each month in order to have access to this benefit. One other question we get a lot is what happens to all of those people who have already applied for EI? So the messaging that we're receiving is that the government is actually basically just moving everyone over to the Canadian Emergency Response Benefit. So if you've already applied for EI, you don't have to apply again for the Canadian Emergency Response Benefit. You're literally just going to be transferred over to the new system. And it doesn't look like there's going to be an option to elect which benefit you want to receive. So you're not going to be able to say, no, I don't want the Emergency Response Benefit. I only want EI benefits. And that might sound crazy. Why would somebody care about that? But actually, for some people, the amount that they would receive under EI is going to be higher than the amount that you would receive under the Emergency Response Benefit. So that's why some people might want to have the option to elect, and that does not seem to be a possibility at this point in time. The good news is that for everyone that would have received less than $500 on EI, you're going to get the full $500 per week through the Emergency Response Benefit. So that's great. Other leaves, such as if you're starting a parental leave, you are already planning to do that, those will still go through the regular EI process. So don't worry about that. We do still have a lot of, even though this is the benefit we know the most about, we still have a lot of questions. Some unknowns that still remain to be addressed are things like, are employers going to be able to provide top-ups to employees who are receiving the emergency response benefit the same way that they may have been able to do that for employees who are on EI benefits? So that's not clear at this time whether that's going to be something that's available for employers to do. And of course, there are some other questions that remain to be seen, and we'll probably get more answers as the applications start opening up. So before I move on to talk about employers, I just want to mention that there are a lot of other initiatives out there that are available to individuals who need assistance that aren't related to employment. So highly recommend that you check out not just the federal government's website, but your provincial government's website. Even look as narrow as your city's initiatives to see what they are doing to help individuals. I know, for example, at the federal level, they've increased the Canada Child Benefit. There's been some GST credits that have been given out. Everyone's been provided with extra time to file their income taxes. And I know most of the large banks are also doing mortgage deferrals on a case by case basis with individuals. So there's a lot of options out there to support individuals. We're obviously just focusing on the employment law sphere, but I definitely want to highlight that there are other options available for individuals who feel like they need assistance. So let's move on to talk about supports available for employers. So the first thing, obviously, I'm going to talk about, because everyone is extremely excited about it, is the Canada Emergency Wage Subsidy, which we are continuing to get more details on as by the hour as things are updated. So unlike the emergency response benefit, this would be the benefit I would say we know the least about. We are slowly getting details, but nothing's been literally nothing's been written yet. The legislation has not been put out, so us lawyers have not had a chance to pore over it yet and dissect every single detail. So what we're going to provide to you is the information that we have to date, which has been provided or gleaned as a result of watching various press conferences and accessing the information that's available online. So basically, what is it? So it's designed to provide a temporary 3-month wage subsidy to qualifying employers. And so the period of time, just to be clear, I know we're talking about 3 months, but it's actually March 15th to June 6th. So that's the qualifying period that we're talking about. The wage subsidy is designed to be 75% of an employee's regular wages, up to a maximum of $847 a week per employee. So basically, they're providing 75% of up to $58,700 annually. So that's what's being provided. So how are they calculating this subsidy? We've got a lot of questions and unfortunately not a lot of answers to those questions as of yet. We do know that for existing employees, so an employee that was employed before the COVID-19 outbreak happened, basically the benefit is going to be what they call the lesser of either the amount that they're actually getting paid right now to a maximum of $847 a week, or 75% of their pre-crisis weekly remuneration. And we don't have information about how average weekly remuneration is going to be calculated. Obviously for salaried employees, that's easy, but there are a lot of employees that work on an hourly basis or whose schedules fluctuate week to week. So we're still waiting for direction on how that's going to be calculated. Just like the emergency response benefit, employers are going to have to reapply each month for the wage subsidy. So you may not qualify for 1 month, but still qualify for 2 and 3. So what's the criteria? Who can apply? So when we were first hearing about this subsidy, the way it was being described suggested that it was only going to be available to small and medium-sized businesses. But luckily, that's not the case. So actually, the only criteria for eligibility for this benefit is that your revenue has to have decreased by at least 30%. And the comparative that they're using is the same month from the year prior. So if you're looking at, okay, in March 2020, did my revenue decrease 30%? The comparator that you're using is March 2019. Now, obviously, this does not work for new businesses. It also doesn't work for businesses that, for example, have recently hugely expanded their operations, who, yes, they have experienced a huge decrease compared to perhaps January, but not compared to March of 2019. So what we've heard, and we don't have any details about how this is going to work, but we've heard that this criteria is going to be applied flexibly, so that so that everybody will have an option, who should have the option to take advantage of the wage subsidy. The other thing that's really important to note is that this is not available to public companies. So it's available to individuals, partnerships, corporations, not-for-profits. There's no size threshold. There's no limit depending on the number of employees. But unfortunately, if you are a public company, you're not going to be able to take advantage of the wage subsidy. The other criteria that's really important to keep in mind is that the company has to show that they're doing everything they can, a lot of air quotes here, to pay the employees the remaining 25% that's not subsidized. Now, we don't know what that means right now. We don't know how this is going to be tested. We assume that there's going to be some form of a statement that employers have to sign off on or agree to. But we don't know. And until the application process opens, we don't know what that's going to look like or how they're going to assess a company's efforts to pay the remaining 25%. What we do know from the Minister of Finance's remarks is that the government is aware that for some companies, this is not going to be possible. So there are going to be companies out there who can't even pay 1% on top of the 75% subsidy. And they've been pretty clear to say that's not going to disqualify you. But I imagine that there's going to be some requirement to show that you've at least done your homework to show that, okay, this is impossible for us to do. It looks like funds are going to be paid in approximately 6 weeks. So about middle of May 2020 is when these funds are actually going to be available to employers. And we're expecting the application process to be available soon. We don't know what that means, soon. Again, we're still waiting for the legislation that's going to give us more details. The last thing I want to note about this is that employees who are being paid pursuant to the subsidy are not eligible for the emergency response benefit or EI benefits, and it applies vice versa, of course. So if you've got employees in the month of March who have already received EI or have already received the emergency response benefit, you're not going to be eligible for the wage subsidy for the month of March. Oh, I lied. I have one more thing to say. So you may recall that before we got this 75% wage subsidy, we were told that there was a 10% wage subsidy available to employers that they could take advantage of by basically just reducing their remittances to the government. So there was no application process. It was just if you applied, you can just deduct from the remittances that you were giving back to the government. This is still available. So we're being told that employers can still do this. But the only thing to keep in mind is that this is going to decrease the amount that you would be eligible for under the 75% wage subsidy. So just keep that in mind. So I am monopolizing time a bit, so I'm going to go a little quickly through the rest of this. But other things that we want to be aware of as employers is the work sharing program. So the work sharing program is an Employment Insurance Service Canada initiative that basically allows employers and employees to agree that the employees are going to reduce their hours. So a group of employees is going to reduce their hours in order to basically share the hours that are available. Generally speaking, the requirement for this is that you have to have experienced a decrease in business of at least 10% to warrant the need for this sharing of hours. The great thing about the work sharing program is that under normal circumstances, an employee who has their hours reduced would not be eligible for EI benefits, as we know, because you have to have been off work for at least those 7 days. But through the work sharing program, it is possible for an employee to receive EI benefits to help them kind of bridge the divide between the decrease in their earnings as a result of the decrease in their hours. So that is a great initiative, really great option for employers who still need their staff, but just don't have the same hours available and need to kind of spread the work out amongst their employees. The next thing I want to talk about is the Supplementary Unemployment Benefits Program. So essentially what this is it's a program that allows an employer to provide a top-up on an employee's EI benefits. So if an employee is receiving 55% of their earnings through EI, an employer could say, you know what, I want to give you another 20% on top of that, so we're going to bring you up to 75%. The Supplementary Unemployment Benefits Program allows employers to do this as long as their plan is registered with Service Canada. So, and the reason that this is significant is because you can imagine if you as the employer say, I want to be nice and I'm going to give my employee 20% of their earnings. If you haven't registered your plan, Service Canada is going to say, well, hold on a second, this employee is now receiving income. Maybe they're not eligible for EI, or maybe we have to significantly reduce the amount of money that they're being given as a result of the fact that they're still earning income from their employer. So the Supplementary Unemployment Benefits Program allows an employer to top up employees' EI benefits without it counting towards their income or hurting their ability to be eligible for EI benefits. So that's a great program that's available for employers. One of the huge benefits that this has for employers is that it will allow you, at least in Ontario and in other jurisdictions, I believe as well, to extend the length of a layoff period. So if you have laid an employee off, Stuart mentioned that it's 13 weeks is the general length of time that an employee can be laid off for. But if you are providing supplementary unemployment benefits, you can actually extend that period to up to 35 weeks. So that's why I've got it under the support for employers heading, because even though, yes, it's beneficial for employees, it also has legal implications for employers, which are helpful and give you more flexibility. The last thing I want to mention is just that the federal government has developed what they call a business credit availability program. There's a lot of interest-free loans that are available to businesses of all sizes. And again, just like I mentioned for employee support, there is a lot of other programs available to assist employers, particularly small businesses, things like adjustments to hydro pricing, exemptions for employer health tax, deferral of WSIB premiums. So there's a lot of other initiatives out there that can be helpful to employers. I'm going to turn it back to Stuart now to talk about keeping your employees safe.
Great, thanks. Hopefully, yeah, I'm not muted. Okay, thanks for that. Let me go to the next slide. Yeah, and thanks for all that. I know you did monopolize a bit of the time, but there's a ridiculous amount of stuff to cover. So I appreciate that, and it keeps changing. And the bottom line is, every level of government realizes that people need help now, so they're acting really quickly, which sometimes means acting and then changing their mind when they realize that what they did initially was not going to be enough. And when it comes to the wage subsidy, I think this was a recognition that without this, there were going to be just massive numbers of layoffs, many of which, of course, would be breach of contract, as we talked about. So hopefully that's going to prevent a lot of that. So anyways, I know we got a little bit of time left. So I do want to talk about a situation where we are still operating, either fully or partially. You're still got employees. And of course, as I'm sure everyone knows, as an employer, you have an obligation to keep your workers safe. You have an obligation to take all reasonable steps to maintain a safe work environment. Now, normally that has certain connotations. In the COVID-19 world, it has somewhat different ones. So first of all, social isolation, working remotely. That is the ideal situation. That is what our firm is doing. If you strip away the virtual backgrounds behind Brittany and I, you'll see that we're both actually at home, and everyone in our firm is, and a lot of our clients are doing the same. So if it is at all possible to have all or even some of your workers work remotely, that is the ideal, and that's what you should be doing. If that's not possible for some or all, then social distancing is the key, which means keeping your workers apart from both each other and from customers and clients. So I know, Brittany, you mentioned this, actually I guess it was in our pre-conference chat. We were talking about, going into stores and having X's on the floor. And if you go into a grocery store, maybe only every second or third line that's open, and there may be physical barriers between them, or you may have lines as to, you can't advance until the person ahead of you is a certain distance away. Same thing between workers. There's got to be distance between them. So maintain the distancing as much as you possibly can. Allow people to use protective equipment like gloves, like masks, whatever else. Again, within, as long as it doesn't interfere with their ability to work, in which case you'll have to judge what's feasible. If you have a health and safety committee, and depending on the size of your organization, you may have to, now's the time to activate them. They should be front and center trying to figure out what to do. And one of the things, a suggestion that I had from a client actually, is to, I'm just looking at my notes here, is to make sure that there is a system in place where people can inform the employer of any concerns regarding potentially being exposed to COVID-19 in the workplace. So have a very clear system, let everyone know what that system is so they know who to talk to. Obviously providing soap, providing hand sanitizer, washing everything. If you've gone to stores recently, especially grocery stores, you'll see they're constantly wiping down everything. So keeping things as clean as you possibly can is critical. And wiping down, doorknobs, door handles, faucets, everything you can think of. I've got testing with a question mark here because I know a number of organizations are now starting to ask every employee to submit to a temperature check when they come in and make sure they don't have a fever. Now, there is certainly an argument there that that's going to be a breach of their privacy rights. And obviously, we've not seen any decision on that because this is all new. But it's not a bad, look, it's a very effective way to help make sure that people with the virus are kept out. It is risky, but as long as you can justify it in the workplace, or if your employees agree, it's certainly not a bad idea. Other suggestions that I've had from clients and other people, the constant cleaning I've mentioned already. Oh yeah, I guess it should go without saying. If you have employees who are exhibiting symptoms, or of course if they tested positive, you got to send them home. That should be obvious. And I've also mentioned the right to refuse work, because we're getting this in many different contexts. As Brittany explained, there are leaves of absence available to people if they either are exhibiting symptoms, have been ordered to self-isolate, return from travel, or if they have to look after family members. But we've also had employer clients who call us and said, look, my employees or some employees just won't come to work. And we've had employees who called us or consulted with us and said, what if I don't want to go to work? What if I don't feel safe? And one of the messages we've been giving is that there is always a freestanding right to refuse unsafe work. That has always existed. But it doesn't apply if you're just concerned generally because there is a pandemic, and not to minimize that. It only applies if there is a legitimate and objectively defensible reason for the concern. So again, the extreme example of you're being asked to work next to someone exhibiting symptoms. That would be a reason to claim that you feel unsafe and you don't want to work. But it can't be because you just feel unsafe given the nature of the virus. And the other thing that comes up a lot is you're not concerned about the workplace, you're concerned about getting there, using public transportation. So technically, that would not be an excuse not to go to work. The same way that showing up late for work because your bus was late is not a valid excuse. So practically speaking, again, we've been trying to get our clients to work together as much as possible, and most people have. So that's, if they can work remotely, obviously that's the ideal solution. If they can't, is there another solution? Short of carpooling, as I've had people suggest, because that would not be wise in the era of social distancing, try to find a solution. And as well, we've had clients who said, look, we need to cut costs. If I have someone who's saying, I don't want to come to work, and they will agree to a layoff, that might be the best solution. If they're happy with it, you're happy with it, you don't need them in the workplace, that might be the best solution in that case. But otherwise, they can't just refuse to come to work because of COVID-19. So I guess a few parting thoughts. One thing, and I may have mentioned this at the outset, biggest frustration for employment lawyers, and our firm in particular, is people acting without having enough information, understanding their legal rights and their legal obligations. People make assumptions based upon what they hear in the news, what their friends say, what they think must be the case, and that's not always correct. And it's particularly not always correct in this context. Again, layoffs being the best example. And so what we're concerned about is people are making, your businesses are making decisions to try to cut costs, and it may end up costing them a lot more in the long run. Imagine a situation where you temporarily lay somebody off for, let's say, 13 weeks. So you've saved 13 weeks of salary, but then they turn around and claim constructive dismissal, and they succeed, and they get a year and a half of severance. Now that's a potential scenario. So you want to make your decisions based upon all the relevant evidence, all the information, and of course, understanding the law, and then make an informed decision. That's why we do sessions like this. That's why we have very active social media platforms, especially in the last couple of weeks. And as is up on the screen, it was not possible to do a blog post every time something changed. So we've got our running blog, and we just put up, generally short updates whenever there's something COVID-19 workplace related. So please feel free to keep up to date there. At the end of the day, I said at the beginning, I'll say it now, this doesn't replace legal advice. So please, and I've started to say this quite often on our monthly show, if you think you might need an employment lawyer, you probably do. So feel free to reach out. If we can help you, that's great. If we can't, there's no harm done. But it's certainly better to make that informed decision than to take a chance and then have to try to fix the mistake you made later on. So I think we have a few minutes left for questions. What is the time? My watch is off. I got about 2 minutes left, and I think we've got at least one question. I guess I can take the first question from Jane if that happens. So Jane, you asked, what are your thoughts on offering an early retirement program as an alternative to layoffs? I mean, I think it's a great concept, and like we've been saying all along, the idea here is work together. So if you have employees that you think might be interested and they're willing, then you can agree upon that. Obviously, when we talk about early retirement, that is not termination. So you can't impose, well, you could terminate someone. Again, as I said before, you'd have to pay them severance. But if they're willing to go through this program and they agree, that's great. The only concern may be if you're sort of picking them based upon age, there could be a human rights concern there. But again, if you're just discussing it with them and not imposing it upon them, you should be okay. So that's certainly an alternative. That any discussion's open as long as you're not imposing things. And you're not picking people and doing anything that will impact them negatively because of a protected ground under human rights legislation. So I'm not sure if we have any other questions.
I think we've got one more from Colleen, who was asking, can we legally have every client staying at a healthcare boarding facility tested? I'm not sure if this is in regards to the temperature testing that Stuart was describing, in which case I think that his comments are applicable here, of just that, if you've got a reasonable basis, and it's to protect the safety of your other staff members, then there may be a justification for testing. In a case like this where, there is maybe a more than average risk that they've been exposed, you may have more grounds to institute testing, but you do have to be careful, as Stuart was mentioning, about privacy rights, and you definitely don't want to overstep. So normally Canadians are very guarded about our privacy rights, and medical testing is not something that is generally supported unless there's a really good basis for it. So this is obviously an unprecedented situation, and we're kind of flying by the seat of our pants. But if you've got a legitimate reason, a legitimate concern, then yes, you may be able to institute testing.
Yeah, so you got to be careful, but again, it's unprecedented, so you may be able to justify it.
Right.
I think that's all the questions we have, actually. So we will remind everyone once again to please make informed decisions. And as we often say, it's always less expensive to prevent an issue than it is to fix it later on. So there's a whole lot of information on the screen. We've got information about our blog, about our social media platforms. Fire Away is our monthly show, which we talked about COVID-19 last time, and I'm pretty sure we'll talk about COVID-19 next time. So more information there, YouTube, podcasts, and we already mentioned before the running blog. So at the end of the day, please feel free to reach out to us, and if we can help you, we'd be happy to. If we can't, there's no harm done. And we'll just remind everyone, please stay safe and stay informed. And thank you very much for tuning in. And Rhonda, I'll turn it back to you.
Oh, great. Thank you, everyone, for joining. And thank you so much to Stuart and Brittany for an excellent presentation. This is approved for one HRCI Global credit and one SHRM credit. We at HR.com will send you your credit information within 24 hours or a couple of business days. You can also go to hr.com, your profile, within 24 hours to see your credit information there as well. And we will also post this on hr.com in the archives, so you can go and view that within 24 hours as well on hr.com. But all of that will be in an email that we will send out to you, we promise. All right, so thanks again, everyone, and take really good care. Bye now.
Thanks again.
Bye.